Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Professor Gyampo akasa afa Attorney General versus the OSP versus High Court ruling now or the Btwn some few days back. Now, Professor Gyampo said there is some secret fight between the OSP and the Attorney General. Now, a dainty and Emma Professor Gyampo same way. I hold details video way. Now, come home. Now, you could see the details from Professor Gyampo. There is some secret fight between the OSP and also the Attorney General. A higher PENDREAM TV. Subscribe to the channel. Bell notification no. Now share my afofro and sa and can be comment section ho. Nowadays, what venture up.
High Court ruling earlier this week that has generated some concern. In fact, the two major references this morning is with regards to Article 88 and then subsection 2 of Section 4 of the OSP Act. Gentlemen, now this is it. There shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. The Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. Also, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. The emphasis is on 88.4, which is all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. This is what the law that sets up the Office of the Special Prosecutor also says. Section 4, subsection 2 of Act 5959 says, subject to clause 4, which I just read, of Article 88 of the Constitution, the Office of Special Prosecutor shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. Now, this week, the General Jurisdiction Division 10 of the High Court here in Accra ordered that the Attorney General should take over all prosecutions by the Office of the Special Prosecutor. Immediately take over all the criminal prosecutions currently being handled by the Office of the Special Prosecutor. Now, pending formal authorization from the Attorney General's office, and that's why I read this too. It puts these matters in context. In this ruling this week, which has become a matter of contention, the court also declared all ongoing prosecutions initiated by the OSP null and void, effectively halting multiple cases across various courts. Now, the issue that has come to the fore is whether the High Court overreached its powers in making these orders. In fact, when we got the full details of the ruling, that matter was addressed by the trial judge in it, which I'll show to you. And then also whether indeed the special prosecutor really does need to go for authorization on every case from the Attorney General. There are two schools of thought on this matter. The Attorney General himself, the Deputy Attorney General himself, has been responding to this, including whether there's a tough war that has led to all of this. Dr. Justice Adam Sremsai spoke to my colleague exclusively, Eric Mawana yesterday. Ahead of today, he was to join us this morning, but something came up, so we had to go speak to him to state his position. I want us to take a listen to Dr. Justice Adam Sremsai on the Attorney General's position on this matter, because the day after this ruling by the High Court, he put on his Facebook page that the Attorney General's office is already taking steps to take over the cases that the OSP is prosecuting as per the directives or the decision of the High Court. So why did he even say this in the first place? There are those who are asking, how he can actually then overstep or take away that option of rather giving the OSP the authorization to continue the prosecution of these cases rather than taking it over, as was earlier stated by him. Quickly.
Well, thank you very much. Way back in 2008, I recall the Ghana Political Parties program that then had representation of all the political parties that had seats in Parliament had commissioned a study led by one Professor Reginald Austin and Professor Kofi Kumado to audit the gaps in Ghana's democracy. That study culminated in a certain paper that was also referred to another committee comprising people like Professor Kwame Ahoy, Professor Yauchumesi, Dr. Ahaji. In their further study of trying to audit the gaps in Ghana's democracy, generated a paper called Democracy Consolidation Strategy Paper that generally argued that even though Ghana's 1992 constitution had served us well, nevertheless it contained provisions that were hindering the maturation of our democratization process. So they identified the gaps and made recommendations for constitutional review with a view to addressing the gaps. Now, one of the challenges that they identified in their audit of Ghana's democracy was about the fact that we have an Attorney General who is also the Minister of Justice. And they had argued that in the fight against corruption, it is oftentimes difficult for a certain Attorney General to be dealing or prosecuting his own other colleagues who are serving within the same government with him. And so the recommendation that was made then was the need for us to separate the Attorney General from the Ministry of Justice and then create an office that they were referring to as independent public prosecutor. An independent public prosecutor. In fact, if you read the Democracy Consolidation Strategy document, whose recommendations were bought into by Professor Mills and culminated in the Constitution Review, that was the recommendation that was made. You need to separate the Attorney General's office from the Ministry of Justice and then create an independent public prosecutor, not special prosecutor, independent public prosecutor. People had their own fears about it, that if you don't take care, this guy would also be prosecuting all your appointees and all that. But then that was the recommendation. Soon after President Akufo-Addo became president, I think he was also privy to this conversation. But he was aware that in trying to separate the the Attorney General's office from the Ministry of Justice, and in trying to touch the prosecutorial powers of the Attorney General, it was going to require a certain constitutional amendment, and that particular Article 88 of the Constitution is actually an entrenched clause. So I think the easiest way out that he resorted to was to create the special prosecutor. And when this was done, some of us had issues with it. I mean, right from the word go, because we were juxtaposing the special prosecutor that had been created, its functions, with the provision in Article 88 that vests the prosecutorial powers of the state in the Attorney General. And so right from the word go, we knew that there were going to be problems. But, you know, Ghanaians were also tired of corruption. And so once you had a special prosecutor set up, and particularly what excited people in not delving or thinking deep into the problems that could arise was the appointment of the person in the persona of citizen vigilante. So people applauded it that, well, I mean, with this man, no nonsense person is going to do the job. So that sort of blindfolded people into looking at the potential conflict that could emerge. And so Amidu left, Kisi came, and it's been on and on. I mean, I quite remember one day I was arguing that the special prosecutor was going to have problems because he was going to be working in the shadows of Attorney General. And somebody drew my attention to the fact that, look, their act says that even though they are going to be drawing their prosecutorial powers from the Attorney General, they nevertheless are expected to operate, you know, in an independent manner. And I kept asking myself that, how do you draw your prosecutorial powers from AG and still be independent of the AG? And today, somebody has gone to court and he's gotten a judge to give a certain judgment.
Also, when the AG could even internally prosecute, even through your prosecution.
That is it. So somebody has gone to court and gotten a certain judgment, and I think now we are all awakened to the realities the realities of the conflict that right from the word go was created by the passage or by the setting up of the office of the special prosecutor. Look, this matter, if you don't handle it well, if you don't talk about it well, then you are seen as somebody who is now developing a cold feet against, in the fight against corruption. But the point is that reality is setting in. We are all tired of corruption. We want corruption to be confronted head on. But at the same time, we must also not blindfold or be oblivious of the legal contradictions and the realities that confront us. Now, so an individual has gone to court, and this is a ruling.
Okay.
Are we now going to look at the court and tell them that they are wrong without seeking a review? So I think that, look, what has happened has generated a lot of public discourse on this. Anti-corruption crusaders, some of them are looking at things dispassionately. I can see some of them are also being emotional. That no, I mean, why are you touching the special prosecutor? But I'm saying that we cannot confront corruption without looking critically about some of these legal contradictions that exist. Because if we blindfold ourselves to the realities, then we may be going a certain tangent. Somebody gets to the court, and then he throws sand into our gari, and then we are all disappointed. So I think that the time,
the consequences.
The time has now come for us to all sit and look at things dispassionately.
Okay.
What are whether we want the office of the special prosecutor to operate in the environment of this legal contradiction? It's up to us to decide. The office of special prosecutor, in my view, has got the option of either going to the AG and getting whatever authorization so that he can continue his case. He also has the option to go to court to seek a review. But ultimately, it is important for us to appreciate the fact that you cannot allow this kind of contradiction to exist, particularly when we have not done anything about the prosecutor, about amending the prosecutorial powers, of the AG in a manner that gives it, hives it off to the special court. If we've not done that, then anybody can go to court, and once they get this kind of judgment, then you can't blame anybody. So the point is that we must be open about this, be dispassionate about it, and see how we can navigate, this particular situation in a manner that will not make us look like we don't want to fight corruption, in a manner that will not also make us look like we are seeing problems in terms of conflict of laws, and we want to pretend that because we want to focus on a particular tangent, that conflict should
on the matter of the authorization, Dr. Adam Sensai stated in that interview that according to him, said the OSP is not interested in coming to him for the authorization because the special prosecutor says that office is independent. That's according to Sensai.
Well, but I don't know what the lawyers here say, but I think that to the extent that nothing, if nothing bars the special prosecutor from going to the Attorney General to seek clearance to be able to prosecute, then I don't see why we shouldn't be able to do that. It appears also that reading in between the lines, I think there's been some theft wars, but whatever is happening, the point must be made that the prosecutorial powers that are given to the Attorney General are quite entrenched, and you cannot just push it aside and pretend it doesn't.
That's why I started this conversation with the details of those two provisions, Article 88 and Section 4.2 of the OSP Act. You want to say something quickly?
So I respectfully, Prof, your statement that reality is now settling in, I think is far from the truth. I'd like to take you back to the Hansard of November 1st, 2017. And I want to point out to you that these issues were thoroughly debated. Ghanaians are not now waking up and finding that all of a sudden the wording of the Constitution is this and LI 2374 and we are hitting our heads. Not at all. So let me read a bit of the Hansard for you. And I would like to appeal to Ghanaians to spend time, go to history so that we don't seem to be reinventing the wheel all the time. Now, the debate regarding the authorization of the OSP as it had folded was as such. Mr. Banda, who was a proposer of an amendment to the Article 88 that we are looking at, he moved an amendment to insert the phrase that the OSP shall be authorized by the Attorney General. His rationale, his goal was to strictly tether the newly created Office of the Special Prosecutor to Article 88 of the 1992 Constitution, which vests all prosecutorial powers in the Republic in the Attorney General. Then Dr. Dominic Aine, the pragmatist, what was his position? He supported the concept of authorization, but vigorously demanded that the method of authorization should be explicitly defined and structured. His rationale, he argued that since Parliament was using a statute to compel the AG to delegate authority to the OSP, there had to be a clear mode of delegation. He explicitly suggested using a constitutional instrument or a legislative instrument to spell out the jurisdiction, ensuring that the OSP will not be left in an administrative limbo. Then Prof. Mike Okwe, the speaker at the time, an independent purist, his position, he pushed back. He said that the entire concept of the OSP needs an explicit warrant or authorization from the AG to do his job. His rationale, he believed that an act of Parliament creating the office was authority enough. He delivered a prophetic warning that demanding ongoing or secondary authorization from the AG would open an unnecessary Pandora's box of co-ranto legal challenges demanding to know by what authority the OSP acts, whereby paralyzing the anti-corruption fight. Which position won? There was a structural compromise won. Parliament could not ignore Mr. Banda, and so the legal requirement for the AG's authorization was kept in the Act. However, to prevent the exact paralysis the Speaker warned about, Parliament adopted Dr. Aine's solution. They created a framework for structural delegation rather than requiring case-by-case permission slips.
Is that from the Hansard? You are interspersing with comments. Read the Hansard, they know.
Let me finish my point. Let me finish my point.
Get serious.
So the OSP eventually, and so I'm trying to say that to suggest that this is new.
Okay.
Read the Hansard.
To suggest that.
But I think it's instructive that you reference that a member of Parliament also raised the possibility of what we're even seeing now.
Absolutely.
With the co-warranto application that has resulted
in saying something different.
Yes, I'm saying we are all forgetting the history. Let's go back to the Hansard and see that this issue was dealt with. It is not that we suddenly woke up and then we are surprised. No. The issue came up, it was debated, and they agreed on a certain compromise. That compromise is what is reflected in LI 2374. So even if we are having this discussion now,
LI?
But the LI is
Which
but just for the at least specifically, this point was made. Hold on. I want to hear one person. Listen.
No, the constitutional provision.
Hold on. This particular LI was referenced in the course of the engagement, and the compromise, so-called, that was captured in
Absolutely.
there. Because of Article 11 and the sources of law and the hierarchy of the laws, the question as to whether the LI supersedes the constitutional provision is one
it
that
does not.
also then. So then, how do you reconcile
No,
this
but
position?
the Constitution says delegated by law. Do we have a law? We do. Act 959. Does that law empower the OSP to do what it's doing? Yes. Has it been repealed? No. Does it talk about investigation and prosecution? Yes. So unless we are saying that the Act 959 does not satisfy what is required by Article 88.
Exactly.
No, but that's not the case. It does satisfy.
It doesn't. If it did, the judge wouldn't have ruled that way. That's what the problem is.
But that's an issue of interpretation.
No, only interpretation.
No,
it's not
It's an issue of interpretation.
Thank you. On this,
there's been instances where the agencies, other state agencies, law enforcement agencies that we give fiat to prosecute cases have been questioned. I remember one was on SEPS, Custom Excise and Preventive Service.
Giving them a fiat to be able to prosecute.
Yes, so that was, they used to be called SEPS, now they are part of GRA. At the time they were SEPS, they had a fiat to prosecute. But when the legislative review came and they became part of GRA, GRA is now a new legal entity. They were prosecuting someone who said that they didn't have a fiat. They were trying to say that they had a fiat when they were SEPS or something. But now they don't have it. The courts decided in that case that since you don't have the fiat, you couldn't, Recently, there was a couple of cases like that. So this is just a normal thing that happens if you are, of course, if you are being prosecuted and you have any doubt as to who the authority of the person prosecuting you, I think you are entitled to, as it were, challenge it. And that's what the person did. We were not aware of this case. That's the Office of the Attorney General. Personally, I don't even know this accused person. This file has never come to our office. We, just like everyone else, got to know of the decision that the court has ordered that we should go and take over the cases on grounds that the OSP was not able to show that they have authorization from the Attorney General, contrary to their own act. So the case that happened in the High Court had nothing to do with constitutional interpretation. Because the act, I don't know if you have looked at the act, but the act specifically says that
the objects right in front of you.
Yeah, subject to Article 88, the OSP will prosecute based on the authorization of the Attorney General. That's what the legislation says. So the person is saying that if you are prosecuting me, then you should show your authority note upon which you are prosecuting. That the OSP was not able to show. So the court...
Right, to the extent that a similar matter is currently before the Supreme Court, and in the criminal jurisdiction of the High Court, that judge had stayed their hand, deferring on to the Supreme Court to make a decision. Many will say general jurisdiction could have stayed its hand as well. Yes, that doesn't fall within your remit, but
yeah,
in terms of what played out.
In terms of what, I don't have the full record, but what I know is that the mere pendency of a similar matter in the Supreme Court does not operate as a stay to any court that is deciding. It is good if the court is aware, or it has been brought to the court's attention, and the judge decides that, well, I will wait. That is fine. Even if a judge knows and decides that I won't wait, I will make my decision, it doesn't invalidate the decision itself. Yet you may question the judge's discretion as to whether to wait or not, especially when I have no evidence that it was brought to the judge's attention and he was prayed to stay. But be that as it may, like I said, we were not parties to the case, so we didn't know what happened. The decision has been made, and we have been asked to order to do certain things. So we just have to do it. Why would someone interpret this as we are in a hurry to take over the cases of the special prosecutor?
In reading the orders of the High Court, which has now become the subject of the conversation, yes, he ordered that the AG takes over the cases pending authorization to the Office of the Special Prosecutor.
Precisely.
Many will say that should be of concern to the Attorney General, given that authorization for that matter to proceed.
It is.
Instead of
It is of concern to us.
The decision to want to openly come out and state that, okay, we're taking over, and no mention at all as to...
No. What I put out yesterday did not say that we are taking over cases.
In the coming days?
I said we'll take steps to give effect to the decision of the court, right? So, like you said, we should be concerned because as far as we know, all prosecutions in the country is being done in our name. Right. So if we are there and the court says that there is this number of cases because the OSP doesn't have power to prosecute and is prosecuting, we should take over. Do you want us to spend 1 month thinking about what to do, or you'll be interested? Like you said, we should be concerned. And my understanding of concern means that we should do something to remedy the situation. That is what we are going to do. So why would someone interpret that to mean we are in a hurry to take over the cases? So the point I'm trying to make is that I appreciate I won't call it propaganda, the misinformation out there. Because yesterday I was speaking with someone who said, it was actually a radio, presentation. Somebody said the AG went to court to ask that the OSP be sacked, which, first of all, we didn't go to court. We were not even aware of this case. So
we'll come to the aspect of conversation surrounding whether or not this is a grand scheme of some sort, particularly in relation to the matter before the Supreme Court.
Well, that's Dr. Justice Adam Sremsai there, Deputy Attorney General and Minister of Justice. So he says they are only going on this path to correct a situation with respect to the law that sets up the Office of the Special Prosecutor in itself. Adam Senanu is the co-chair of the Citizens Movement Against Corruption and also the chair of the African Union Advisory Board on Corruption. Thank you, Mr. Senanu. Thank you for joining us this morning. But you see, there is a foundational problem here. Gentlemen, there was an objective, and the reason why the Office of the Special Prosecutor was set up in the first place, to deal with that challenge, for the lack of better expression, of Attorney General prosecuting cases that involved persons that were politically connected or politically exposed or within the party of the serving Attorney General. That was the thinking. Yeah. There was some conversation that preceded the establishment of the office. And as to whether the law that establishes the office is what has created this problem as we are dealing with now. It's another matter that we want to get into. But I recall that the political party's platform, which Prof. Gyampo was part of, the leading members at the time, were the ones who were doing this engagement for the office, for a separate office to be set up to deal with certain cases that the Attorney General, because of the political nature of it, cannot deal with. Was it the outcome that you were asking for?
I'm not PENDREAM TV. Now, so far so good. Say open online portal le Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.